Good morning.
Don't put us on yet. Good morning. We're still waiting on Mr. White.
Okay.
I just opened up the Zoom room. He's usually very punctual. Let me see if I've got an email from him. We're not on the record yet.
Okay. And the plaintiff is the owner of Montreux is participating via phone. My client.
He's going to be calling in?
Yeah, just in case you needed to hear from him.
Okay.
It's just on standby. Or I don't see him, but maybe not. So.
Yeah, he hasn't shown up yet. Well, I don't see any emails.
We did send, it was noticed originally for October 9th, but then the court rescheduled it for today, and we did send the renotice of hearing to Mr. White, along with proof of service. I wonder if I can try to give him a call.
Why don't you try that? He is usually very punctual.
Okay.
Oh, he just logged in.
Oh, okay, perfect.
Shannon, would you put us on the record, please? Okay, we are on the record regarding Montreux LLC versus Robinson. Counsel, state your appearances, please.
Jacqueline Langwith on behalf of Montreux plaintiff.
Thank you, Your Honor. Eric White on behalf of Tom Robinson, who's here in my office with me this morning.
All right, and Ms. Langwith had indicated before we went on the record that she was expecting her client to phone in, but he has not done that.
I think he's somewhere. He just contacted me and said he's waiting. It says he says I'm on the call, but it keeps saying I'm the only one here. Oh, he's doing, oh gosh, he's doing, okay.
If you've got his phone number, I can simply call him and get him on the phone, but he's not shown up in the waiting room yet.
Okay, I will give you his phone number. It is, goodness, get out of there. Contact. 810-923-6732.
And what is his name?
Kyle Rowe, R-O-W-E.
All right, I'll try to get him on now. Was the last four 6732 or 6232?
Let me see. I 6732.
All right, I was afraid of that.
Oh, that's
I
not what you
dragged-
call? Okay.
I dragged my pen and couldn't read my own writing. Quit smirking, Mr. White. You could be held in contempt for that.
That's something I would do, Judge.
Hello.
May I speak with Kyle Rowe, please?
This is Kyle.
Mr. Rowe, this is Judge LaFlamme. We are on the record in the matter of Montreux LLC versus Thomas Robinson. Your attorney is present. I understand from her that you were having trouble getting into the hearing, so we're going to let you participate by phone.
Okay, thank you very much.
You're welcome. All right, I've read the motion and I've read the response. Let me ask you, Mr. White, since you're insisting on some kind of sanctions, how do I really determine frivolity without conducting some kind of an evidentiary hearing?
I believe you have to, Your Honor, and we're certainly prepared to do so. I believe that's exactly what it would take, and I think that you have to. For the plaintiff to file this and simply abandon it, that's exactly why the court rule says what it says. You just can't dismiss without conditions that are to be set by the court. And I think the only way would be to see if it is frivolous. I can tell you, Judge, it won't take long. In my 25 years, this is probably one of the few smoking guns that I've ever had that simply guts their case and really makes me concerned about what the true motivations of the plaintiff are. But it won't take long in an evidentiary hearing to see the culpability of the plaintiffs. And I think it could be done in short order.
Your Honor, if I may.
But simply decide, I'll give you a chance, hold on. Simply deciding for economic reasons that it's not worthwhile to pursue a case doesn't translate into, therefore, it was frivolous in the first place.
Oh, of course. And we think that that's simply a ruse. We have some information that would indicate this business reasons is there's absolutely no truth to it. I can't figure out what those business reasons would be. They're not going to be able to show a business reason at all. We're going to be able to show that this has been, for lack of a better word, it's almost some type of setup. Hate to say it. It's a very unique set of circumstances, Judge.
But the reason for abandoning the case isn't what I'm going to be interested in hearing. What I'm going to be interested in hearing is evidence that it was actually brought in such a manner without basis in fact or law for improper purposes, and why they decided.
And I believe you'll see that.
Let me hear from Ms. Langwith.
Your Honor, I really am quite shocked by Mr. White's assertions and actually quite offended. And if you recall the case, our complaint, we asked for injunctive relief and we alleged a violation of an operating agreement. Your Honor, we have a video of Mr. Robinson buying marijuana in contrary to state law and putting the license of Montreux at risk. And he was in control of the building, would not let the other owners in, and had taken property. We filed injunctive relief so we could get back into the building. And as a matter of fact, we came to a settlement order, a stipulated order, that he would stay away from the property and we would be able to get back in. And we did. And then we were shut down while we figured things out. And then Leone Township came and shut us down. We went to court, Your Honor, in front of you, and you found that their ordinance was preempted by state law. So then we were able to open again. They were open for some time, and then lack of business and COVID hit, Your Honor. And they've been shut. They've not made any money. They made $6,000 all of 2020. And what improper purpose was there when we needed to get it back into the building to get our property or the client's property? And the other thing is, Your Honor, the Marijuana Regulatory Agency, the state agency, issued a formal complaint against our client. And the reason we were able to mitigate a fine of less than $10,000, a $3,000 fine, was put in the consent order that we cooperated and we self-reported. The idea that we brought this frivolously is just absurd. And the only thing Mr. White has is a text message from another minority owner that's very vague, says something about, you know, I can't even, it's just vague. No smoking gun. It's a nothing burger, Your Honor. It's a nothing burger. We've paid a fine to the state of Michigan. We've had to shut up. What benefit would Montreux have to shut its own doors? And for some improper purpose to set up Mr. Robinson, well, we don't even want to pursue this anymore because the other owners are just going separate ways. They're moving in different directions. They don't want to be in this industry anymore. They just want to put this behind them. It was a bad business deal. It didn't work out between any of them. Mr. Robinson did something he shouldn't have done, and they needed to report that to the state to save their license. And they did save their license. They didn't get suspended. They paid a fine. You know, and the other thing, Your Honor, is they didn't even file a counterclaim. So yeah, it's just ridiculous. If this text message is nothing, that's what he's going to present at any evidentiary hearing, and it's a nothing burger. It's a complete nothing burger. Your Honor, we had facts, material facts at issue when we filed our complaint, Your Honor, and we didn't file it for any improper purpose. And I think that's all that needs to be determined here.
So, Mr. White, do you have some kind of offer of proof today to show that it was brought in bad faith, maliciously, purely to harass, no valid purpose for filing the lawsuit?
Absolutely, Your Honor. I believe I attached the text messages, and there's nothing vague about them. It clearly showed that Montreux was complicit. I believe it's to the answer, Your Honor.
All right, let me go back to the answer then, because it wasn't attached to your answer to the motion.
Oh, they're attached to mine. They're attached to my answer. These are a series of text messages between the other members.
No, Your Honor, it's not between the other members. Mr. Rowe is not on this text message.
He's not the only member. There's, Your Honor, the problem is they've essentially ran this business like crayon on a bar napkin. There's a number of issues. They tried to buy my client out. He refused. Next thing you know, we have this, oh my goodness, you're doing something wrong. We had no idea. Of course, they knew all about it. They approved it.
That's absolutely untrue.
And I think an evidentiary hearing would show this. That's the problem.
All right, here's what I'm going to do. I'm going to grant the motion. I'm going to condition the filing of any new complaint on payment of costs from this complaint.
I'm sorry, Your Honor, what would that,
That would have to be determined at the time you decide you want to file a new complaint.
oh, if any party, if we filed a new complaint, we'd have to pay the cost of this complaint.
Yes.
We will not be filing a new complaint, Your Honor.
All right.
We're
You
gonna
may-
file,
you may-
we're gonna file a summons complaint shortly, so I guess we'll just address that then.
And we will, and that's when we'll find out that you're filing a frivolous complaint. That's
You
when we'll
may-
find that out.
Ms.
And that's
Langwith,
when
you
will
may,
get-
you may submit a proposed order. Thank you.
Thank you.
Thank you.
Mr. Rowe, that concludes our hearing. Have a good day.
You too, sir. Thank you very much.
You're welcome. So, we're a little early for the next one, but I see there are people out there. Let me see. Hilton and Beer. I see Brendan Beer. I don't see a Pelton. Let me see if there's another name on that file. Shannon, take us off the record. I'm going to leave the meeting room open, but it's not 10 o'clock yet.
I have time to run across the hall real quick.
You do.
Oh, thank you.
Well, I can dismiss the reminder for Shannon's birthday, I see. Why didn't you paste? Do you have something with my Zoom ID on it handy?
Yeah, I do. Do
You do? Okay, I was gonna say, I don't think I
you want me to email it to you, Judge?
No, just tell me what it is. Trying to put it in an email.
It is be 929-993-7935.
Thank you.
Yep.
And now remind myself. Okay, let me get back to my meeting. Let's see. Okay, Shannon, put us on the record. This is regarding Huntington National Bank versus Mar. Francis Wilson is present. Are we expecting anyone else?
No, Your Honor, the receiver said he would be more than happy to jump on if you had questions for him, but I suspected you wouldn't, candidly.
That was a very safe assumption.
Okay,
So
good.
we've got a motion to terminate the receivership and discharge the receiver. There's been no opposition filed to it, and no one else has appeared in my waiting room on this matter. I'm going to grant your relief. Is there a proposed order in what you submitted?
Yes, Your Honor, there was a proposed order attached as Exhibit 4, and my assistant informed me she also sent a separate copy to your chambers for signature.
Oh, okay. I'm just going to sign the one that was attached.
That's fine with me, Judge.
All right, I will get that signed and we'll get that back to you for service. Oh, here it is. Extra order for entry at hearing.
Okay, great.
Great.
Thank you so much, Judge. You have a great weekend.
You likewise.
Thank you.
Okay, your order's all signed.
Thank you, Judge.
You're welcome. Okay, next up is Great Lakes Home Health Services et al. Versus Ewing et al. If I could have all counsel state their appearances, please.
Good morning, Your Honor. This is Ryan Bohannon on behalf of plaintiffs.
Good morning, Your Honor. Brendan Beer.
Hold one at a time.
Okay.
Mr. Bohannon, would you spell your last name for my clerk, please?
Yes, no problem. It's B as in boy, OHANNON. That's all N's as in Nancy.
Thank you.
Thank you.
Good morning, Your Honor. Brendan Beer on behalf of the defendants.
Is that
Good morning,
spelled
Your
like
Honor.
the beverage?
It is, Your Honor, yes.
Good morning, Your Honor. Richard Lindsay, also on behalf of the defendants. Same office, same building, but separate office than Brendan.
Okay, and I think the others are present on another matter, so. So I've read the motion to compel, I've read the response. I was particularly intrigued by the fact that another court faced with very similar issues appointed I don't think it was called a special master, but something of that order, a retired judge, to address the discovery issues and to make a specific recommendation to the court based on that. Why shouldn't I follow that same directive, Mr. Bohannon?
Yes, Your Honor. I think following that directive makes sense for about 85% of what we've requested, but in that case, it was slightly different. It involved a sales employee. So our discovery requests, that the information we are seeking in this case is just slightly different. So it just needs to be some small tweaks that I would think opposing counsel and I could come to an agreement on. Just a little bit of wordsmithing and just a couple of additions that fit into what that discovery facilitator granted.
That would be, frankly, my preference, is that you try to work that out. I would, frankly, if you can't work it out, my inclination would be to engage the same discovery master in this case, to help you resolve the issues, and if not, make a recommendation to the court.
And Judge, if we could, we did file late yesterday a reply brief. I'm not sure if it made its way to you, but there's 5 bullet point categories on page 3 of that brief. And I think those are the only 5 things. I don't even know if they're in dispute. I'm not sure if opposing counsel is disputing to provide those documents to us, but they fall within the same scope of what they're willing to give us.
Let me ask, Mr. Beer, did you get the reply brief and had a chance to review the 5 bullet points that he's referencing?
I did not, but candidly, I was on vacation Tuesday, Wednesday, Thursday. I can't speak to whether Mr. Lindsay might not have done that. So I'd ask if he did.
All right, I'm looking on my computer here because it's in the other office with Brennan. Give me just a second.
The short answer is I did not see or review it because I didn't get back last night until, I don't know, shortly after 5. And so I did not open up and read anything I may have received yesterday, but if Richard did, that's.
Ryan, who sent it to us yesterday? Do you know?
It was sent at about 2:30 by Michelle Beveridge. And then I sent you guys about 2 or 3 emails yesterday asking for someone to talk.
All right, hold on just a second. I looked at it, but I don't want to commit to what was in the.
So here's what I want to do today. I'm going to adjourn your hearing for 1 week.
Okay.
I want you to talk about this and see if you can't resolve it. If you can't resolve it, my inclination, unless you can convince me otherwise a week from now, would be to engage the same special master involved in the related case to do what he did in that case, only with respect to the issues that you've been unable to resolve.
Okay.
That sounds good.
Okay. Good luck to you.
Thank you, Your Honor.
You're welcome.
Thank you.
Let me just put that on the docket.
Would you please? Let me just chat with you about that.
Sure.
Okay, and let's see. Next up is Port and Noy LLC. Approval of purchase of a structured settlement. Mr. Grand is here on behalf of the transferee, I'm sorry.
Good morning, Your Honor.
And I've got Megan's iPhone. Would you state your name, please?
My name is Megan LaMaire.
Spell the last name.
LaMaire.
Gotcha.
Okay, go ahead, Mr. Grand. Did you want me to put her under oath?
Yes, Your Honor.
Ms. LaMaire, would you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I know you've already stated your name, but please state it again.
It's Megan LaMaire.
Go ahead, Mr. Grand.
Thank you. Ms. LaMaire, it's my understanding that you are proposing to sell to my client portions of 2 lump sum structured settlement payments that you're due to receive. Specifically, $100,000 on August 31st, 2024, and $192,013.56 on August 31st, 2029. Is that a correct statement of your understanding of the payments that you're seeking to sell to my client?
Correct.
And
Mr. Grand, what was the year of the first payment? I got the month and day, but I didn't write the year down.
2024.
Thank you.
And Ms. LaMaire, it's my understanding that if this is approved, you will receive $156,268.26 in exchange for those 2 payments.
Yes.
Ms. LaMaire, do you understand that functionally, well, this is a sale of those payments, is functionally equivalent to your borrowing that $156,268.26 and paying it back to my client together with 9.25% per annum interest with those 2 payments in the payment in 2024 and 2029?
Yep, correct.
Ms. LaMaire, it's also my understanding that if the court approves this transaction, you will still have $150,000 out of that 2024 payment and $100,000 out of that 2029 payment that will still be coming to you.
Yes.
It's also my understanding that there is an additional $1 million payment that you're due to receive in 2054, which is likewise not a part of this transaction.
Correct.
Ms. LaMaire, it's my understanding that you are currently single and have a minor dependent daughter who is 4. Do you have any other dependents?
No.
Ms. LaMaire, could you explain to the court why you believe that this transaction is in the best interest of yourself and your daughter at this time?
Yes. Okay. So, along with everybody else in the world, COVID kind of put me in a setback to the point where I have a plan now, but I need to get out of the hole that I am to utilize, because I got a new job and I just got promoted. So I'm in a hole, but if it goes any longer, I'm going to end up losing my apartment because I got maybe 2 months behind from being unemployed because my previous job had shut down because of the pandemic. So I'm looking at starting my about my 5-year plan early. Other than in 2024, I need to start it now. So I'm looking at buying a house so I don't, have to go to the homeless shelter with my daughter, and paying off my debts from my past divorce so I can get my credit score back up and try to, just move on with my life at this point and try to get back on my feet since, the whole pandemic just knocked me down so far. But I'm finally starting to get back with my new job, but it's hard to get ahead when I'm in such a hole, if that makes any sense.
And based on your budgeting, once you pay off the debts hanging over from your divorce and the time when you were unemployed. Will you have enough monthly income in order to pay the mortgage note on the house that you're planning on purchasing?
Yes, I will have more than enough because I won't have a car note because I'm planning on paying off a car, so I have it paid in. I don't have to make a payment every month, and then I'm paying $700 a month right now for a 2-bedroom apartment, so I would utilize that into actually getting a decent mortgage and putting my money into something that I can own and not just rent out. So I have something bigger, better for me and my daughter that I can actually, own.
Your Honor, I have no further questions from, yes, Ms. LaFlamme, I just also want to confirm, my client had recommended to you in writing prior to your signing the contract that you should consult with a financial planner or attorney regarding this transaction. And you at that time decided that you did not wish to avail yourself of that, of consulting with a financial planner or an attorney.
Mm-hmm.
Do you still want to move forward with this transaction today, or would you like for this to be adjourned so that you could consult with an attorney?
I want to keep moving forward with it just because I have a pretty good understanding of how this works in my money, and it was a long thought out process before I even came to conclusion that I wanted to do this.
Your Honor, I have no further questions. I would ask that the court find this transaction in the best interest of Ms. LaFlamme and her daughter and approve the petition.
So, Ms. LaFlamme, you understand that a 9.25% discount rate is essentially the same as getting a loan at a 9.25% interest rate. So my question to you is that something you explored, whether or not there is a bank or a lender that's willing to loan you this money and take your structured settlement as security for repayment of that loan?
Yes, Your Honor. I have went to multiple banks and my credit union, and my credit has been so shot because I got into a divorce about 2 years ago, and he ended up going to jail, and so he didn't have any of the debts on him, so my credit scores went way down. So they will not fund a loan unless I have, I can't even get a house with my settlement, structured settlement, because they need at least 10% down to start with. So they can't take my lump sums as a monthly income, so they can't approve me because my monthly income is not budgeted, for me to get a $100,000 loan. So yes, I have tried multiple places, and they're just like, nope, we can't do it for you. So this is the next best step, I would assume.
All right, very good. I'm glad that you did explore that. I'm very satisfied that this is indeed in your best interest. I think it's a reasonable discount rate in light of many that I've approved in the past. In fact, I think this might be the lowest discount rate that I've seen to date.
Oh, yay!
So that's a good thing for you.
Yeah.
I am satisfied. I'm going to approve the sale of your structured settlements. Counsel, I'm just looking to see if there's a proposed order in your submittals.
No, Your Honor, I did not receive a proposed order from that was approved by John Hancock until recently. Right now, I'm still waiting for Ms. Lamar to sign off on it and return to my office. As soon as I get that back, we will forward it to the court for entry. Hopefully, that'll be later.
We'll watch for that order. Good luck to you, ma'am.
All right. Thank you so much.
Thank you.
You're welcome. Have a good day.
Yep. Thanks.